All right, welcome back, everyone. This week we are going to be talking about the victims' rights movement and services that are offered to victims. This lecture is a long lecture. There's a lot of information to cover. So as always, I will timestamp this and you can go back to sections that you need. I do encourage you to take notes as I always do, just like you would be sitting in class. All right. This chapter covers chapter 4 in our textbook, but also has some things that are not in the chapter. So make sure you're paying attention. With that, let's go ahead and get started. Before we dive into the victims' rights movement, I want to make sure that you remember a conversation that we had. Remember, when we talk about victims, there are different stages to victimization, and there are different types of victims that come out of crime. And so it's not just the individual that is victimized that is considered a victim. You have primary victimization, which is that targeted person, but you also have the notion of secondary victimization, which involves those individuals who are supports to that victim. They may have to take time off work. They may have to help support those victims and things like that. So the immediate, like family, friends, is what we consider secondary victims to these events. And then there's a third level of victimization, and that is tertiary victimization. And tertiary victimization is essentially community victimization. So when a crime happens in a community, it has an effect on that community, and it has an effect on how people interact in that community. So it may require more police presences, property taxes may go up to help fund more police. People may move out of that community, and that community may become non-existent if crime is too high, things like that. So the community aspect is considered our tertiary victimization. Now that we've kind of established the levels of victimization, let's actually talk about the victims' rights movement itself. Now, historically, the victims have not been respected within the criminal justice system. So think back to the 16th century, between 16th and 19th centuries. It really was about victims getting revenge for themselves, or they were responsible for seeking their own justice against offenders. They would get family, friends to kind of help them find those offenders. But there wasn't really like a unified court system that sought for justice. That was really the common norm up until 1704. And in 1704, a major shift happened with the invention of the public prosecutor. This was the first time that an individual was representing state's interest and prosecuting offenders in crime. With this invention, the focus of victimization shifted from an individualistic focus to a community focus. The community was now viewed as the victim, which is still common today, you'll learn about. But punishment no longer focused on fines or restitution to the individual victim, but it shifted toward incarceration as the primary logic in punishment. And essentially that focus was, if a crime occurred against an individual, it really was that criminal committing a crime against societal norms, and so society as a whole was the true victim. And this was really our norm up until the 70s, really. And then in the 1970s, there was a new focus, a renewed focus, 70s, 80s, and 90s, on victims' rights and kind of bringing the individualistic victim back into focus. So in the 1970s, collectively, that era was known as the New Victims' Rights Movement. And it kind of spawned from several different movements that collectively made up victims' rights movements. But the initial part happened in 1973 with an International Symposium of Victimology. And in essence, this symposium was a collection of scholars, of experts that wanted to bring the shift of this system back to the victim. And they pushed for greater recognition of victims' rights. They saw that the individual person had rights in this process, and they wanted to bring that forward. And then in 1985, the United Nations kind of codified some of their thoughts in a declaration, and it was the Declaration of the Basic Principles of Justice for Victims of Crime and Abuse. And so this UN declaration was not law, but it was put out there to show that victims should be brought to the forefront of our focus. Now, while this focus was happening in the 70s, there was some additional kind of movements going on that collectively helped make up that victims' rights movement. The first movement that was going on, rape victims. So rape victims were widely considered the silent victims of the criminal justice system until the early 70s. And then in 1971, there was a protest, I guess you could call it. It was really an event, a collection of individuals that came together to raise awareness of how rape victims were being treated. And this was known as the New York Speak Out on Rape event. And essentially, this event called into question how we viewed rape victims and how we treated rape victims. After all, we were still heavily ingrained with victim blaming in our system, especially when it came to rape victims. We would always look for reasons why they put themselves in the situations to be raped, instead of looking at it as a victim. And then in 1972, because of the New York Speak Out movement, and you really saw this growing trend of having rape crisis centers. And in fact, the first rape crisis center opened in 1972 in Berkeley, California. And the purpose of the Rape Crisis Center was to help victims of rape. Help them through the system, give them some advocacy, kind of help them be treated like victims and not necessarily people who brought their victimization onto themselves. Throughout most of the 70s, attention was toward the medical avenue of how we were treating victims. So you're going to read a lot about it was cold and callous in the waiting rooms, how victims of rape may have had to sit in ERs and all of that. But we were putting victims in a situation where they were really being assaulted again. And this is known as secondary assault. And essentially, we were putting them through invasive medical procedures to collect evidence with people who didn't have proper training, or they had proper training, they were doctors, but didn't have specialized training. Because I think we could all agree that if you are tending to a victim of a rape, you need to kind of know that that's not a typical patient. And there are some psychological factors, trauma factors that go into play there that the medical professionals need to be aware of. And so during the 70s, we were really kind of bringing this all to the forefront of, hey, we need to treat people better. We need to have more specialized training. And in essence, that rose to the invention of the sexual assault nurse examiners, SANE nurses, as we call them. These are specially trained nurses that provide 24-hour coverage as first response care to adults and adolescent assault victims in emergency rooms and non-hospital settings. So nurses saw that services to victims of sexual assault were inadequate and were not equal to the standards of care provided by other emergency departments. These patients had specific concerns about contracting STDs or becoming pregnant as a result of their physical assault. So nurses rose up and began trying to get better care and more specialized care for this subset of population. The first SANE program was established in Memphis, Tennessee in 1976. And then subsequently, you had Minneapolis, Minnesota, and Amarillo, Texas that created these type of programs. In essence, these are specially trained nurses that are trained in trauma, trained in victimology, trained in how to collect evidence in the least intrusive way possible, and these are individuals who are pretty much on call for whenever a rape happens. Now, next week I'm going to have a special guest lecture in my face-to-face class that I will tape or video record for online section. That way you can also view it, but we will be talking kind of services to victims and things like that. You will see that SANE nurses are integral parts of our team when it comes to helping treat rape victims. Currently, there are over 2,000 trained and registered SANE nurses. They have an official federation, that governing body that kind of helps them maintain consistent professional development and things like that. But SANE nurses really kind of evolved from this rape movement and are crucial components. We have several SANE nurses here in Statesboro at our Child Advocacy and Sexual Assault Center. So initially, SANE nurses were in ERs. However, that has since evolved to us having specialized sexual assault centers where SANE nurses are housed, and they're not medical facilities. They're really kind of, they're typically grouped with child advocacy centers and things like that. So all of our SANE nurses in Statesboro are at the CAC. There's currently 800 SANE programs in the United States that train these nurses. And progress continues toward ensuring that trained forensic examiners is available to provide care for every sexual assault patient who presents either at a hospital or at a CAC. So out of the 70s rose this program that was first started in Tennessee that continues on today. Also during this time, there was a growing recognition that it takes a village. And essentially what that means is that there are many people working with the victim that have different focuses, but our overall goal in working with the victim is to ensure that they get the help that they need because of their victimization. So sexual assault response teams, or SARTs, are essentially multidisciplinary teams that are comprised of all agencies working with the victim. Sexual assault teams bring all of those agencies together to ensure that we remain focused on the victim, whether it be law enforcement coming and kind of telling us about how the investigations going, victim advocacy coming together. Essentially, these teams come together, staff cases, and help them kind of make sure that we're ensuring that justice is served for the victim. There are three main goals to a sexual assault response teams. You can read them. I'm not going to read them to you, but essentially it's to help get the victim through the process. This system is a large system, and it takes a long time for things to get done. And so, can you imagine being victimized as horrendously as being sexually assaulted, but then having to navigate the system, go to court? What am I supposed to do? Not knowing what court hearing you're going for, because we all know as professionals that there are many types of court hearings, and each court hearing has a specific purpose. And so with a victim who may not know about that, they may think, well, I've already been to court once, why am I having to go back again? Things like that. Or they may get to court and it be an arraignment instead of a disposition hearing. So you kind of need this multidisciplinary approach when helping victims. So the rape movement was one movement in the 70s that fell under the victim rights movement. But another movement was our growing recognition of domestic violence. And on here, you're going to see intimate partner violence. Domestic violence has grown in our understanding as professionals to now have been changed to intimate partner violence. So you'll hear me use DV and IPV interchangeably. They're the same thing. However, well, I say they're the same thing. We're talking about the same thing. However, intimate partner violence's definition encompasses more than just a man and a woman. During the 70s and 80s, really, there was a growing recognition that domestic violence was an epidemic. Estimates range, but approximately 8.7 million women are battered yearly. And IPV accounts for about 15% of overall violent crime. That number fluctuates and has gone a little higher since our book was written, but we're going to stick with the 15% right now. And then just some staggering statistics. I want you to kind of think about your friend group or your relative group. Now, your close friends, maybe you have 10, maybe you have 20, maybe you have 5. Now, I want you to kind of picture them. Picture 5 women and 7 males that you know. One in each of those groups would have been a victim of domestic violence. That's how prevalent it is. 1 in 5 women are victims and 1 in 7 males are victims. So we began to see this growing concern and growing need to recognize domestic violence as an epidemic during this. And remember, the domestic violence movement is going on simultaneously with the rape crisis movement. So the 1970s is widely regarded as the crime victim rights. And there was a wide range of legislation going on at this time, specifically to help usher in awareness to domestic violence. Now, the 70s was all about recognition, and the 80s was about action. And so in the 1980s, domestic violence shelters started to originate throughout the nation. These shelters were initially meant for women and children who were victims of domestic violence to go to get out of that situation. wasn't until the 1990s that they started to expand their service array. We know now, or you may not know, you will find out because there are several links that you will go to this week around domestic violence shelters. But domestic violence shelters now offer a plethora of resources, job training, career training, offers housing to help people get back on their feet, offers victim advocacy. All of that kind of started to evolve in the 1990s. However, in the 1980s, it really was just about a safe place that women and children could go to. But we also see something something coming around during the 80s as a result of the Minneapolis domestic violence experiment. And we're going to talk about the Minneapolis domestic violence experiment here in a minute. But essentially, you started to see our laws changing in how we handle domestic violence cases. Due to the Minneapolis domestic violence experiment, you started to see mandatory arrest laws begin throughout our nation. And we still, to this day, have mandatory, there are several states who have mandatory arrest laws because of the findings of this experiment. But you can kind of see that the history of our advocacy has grown in this arena. 70s with the rape crisis and the domestic violence awareness, we start seeing a focus in our policy arenas to address these concerns and bring the victims of these crimes back to the forefront to restore them to the community. And as I said, in the 1990s, 80s was really about legislation, 70s and 80s was about legislation. We'll talk about some of that legislation here in a minute. But the 90s was about using the funding from that legislation to grow the service array for domestic violence victims. So before we get too far into service array and kind of some of the legislation, I want to take a minute and talk about the Minneapolis domestic violence experiment, because your book doesn't cover this, but it's something important that we need to be cognizant about, because this kind of revolutionized our laws in terms of domestic violence. The domestic violence experiment was the first controlled randomized test of the effectiveness of arrest for intimate partner violence. Essentially, the study was undertaken to study how law enforcement responded to domestic violence and if there was any effectiveness on recidivism with arresting the perpetrator or not. The study assessed the effects of various police responses and suggested that the arrest of the perpetrator produced the least amount of repeat violence for the same victims within a 6-month period. This is important. Subsequent violence reduced by nearly 50% when the suspect was arrested, as opposed to other interventions. And so essentially, the Minneapolis domestic violence experiment found that when we arrest the perpetrator, subsequent incidents fall by nearly half. Now, we would think, and we did think, that this was all the proof we needed to incorporate mandatory arrest policies. However, the researchers who did the Minneapolis domestic violence experiment cautioned us and made several recommendations. First, the first recommendation was that police should probably make arrests in these circumstances. But in order to be completely transparent, this study needed to be replicated in different jurisdictions, because one of the major flaws of the study was it only was looking at Minneapolis and that jurisdiction. We know that jurisdictions differ in demographics, in policies and procedures, and so in order to make a generalized statement of saying all offenders needed to be arrested for domestic violence, you really needed to replicate this study. And one of the things that the researchers recommended was that mandatory laws should not be implemented based off of this experiment alone. In fact, if you instituted mandatory laws based off of the Minneapolis domestic violence experiment, you would skew future data. And any replication of this study would be flawed because you wouldn't be able to kind of differentiate. So what did we do? Well, the majority of states ignored most of those recommendations and utilized the Minneapolis domestic violence experiment findings as a way to justify mandatory arrest policies. So there was a replication study that was done for the Minneapolis domestic violence experiment, and the findings were mixed on that, which is what the original researchers thought it might be. You take the same study and put it in a different jurisdiction, you did not get the same results. Well, this was very flawed because we had already taken our laws and the findings essentially of the Minneapolis domestic violence experiment. And to this day, we still have several states that have mandatory arrest policies. I've given you websites and a handout that has a chart on it that you can look at as far as what states have what mandatory arrest policies and things like that. But essentially, this was a revolutionary part of the domestic violence movement, was the Minneapolis domestic violence experiment. And it forever changed how we handled these type of laws. All right, so let's move on to some legislation. So the 1970s and 80s was really kind of the rise of the victim, and in the 1980s, a historic piece of legislation was signed into law. That was the Victims of Crime Act, and it was signed into law in 1984. This was the first major act in the United States that focused on the victims. You can read the quote from the book. I'm not going to read it to you, but essentially, VOCA is what we call it, VOCA, Victims of Crime Act. VOCA essentially created federal funding opportunities for victim services. So we saw with the rape crisis movement and the domestic violence movement coming together, making the new crime victims bill rights movement. VOCA was our answer. And essentially it was the first law that focused on the victims of crime. And VOCA has a lot of great things to it. We will talk about the Crime Victim Fund in a little bit, but essentially VOCA created funding opportunities for victims as well as subsequent amendments to VOCA has created different agencies that help service providers who help victims. Then in 2004, you had another historic piece of legislation that came out, the Crime Victims Bill of Rights. And this was the first piece of legislation that codified rights to victims. So we recognize throughout the victims' rights movement that victims needed to be at the forefront of our system. We recognized that we needed service infrastructure to help them through the system and get the treatment that they may have needed for their primary or secondary victimization. But it wasn't until 2004 that we expressly stated they have rights in our system. And in 2004, with the Crime Victim Bill of Rights, this legislation laid out the 12 major rights that all crime victims have. Those rights include protection from the accused, timely notice of court hearings. They have the right to be at court hearings. They have the right to be reasonably heard at the district court level. They have the right to timely and full restitution. They have the right to be treated with fairness and respect. And so we fully codified this through the Crime Victims Bill of Rights. Now, this is the federal Crime Victims Bill of Rights. Georgia has its own Crime Victims Bill of Rights. You have a link to it, and I just kind of wanted to bring it to your attention that state, just, you know, we have a dual system, so the Crime Victims Bill of Rights federally recognized. Georgia also has a state recognized Victims Bill of Rights. So a big proponent of restoring the victim back to pre-offense status, behavior, however you want to call it, is this debate around compensation and restitution. And in the 1960s, we started to have this debate internationally. So legislation started to emerge internationally dealing with compensation. It originated in New Zealand. In most states, victims' compensation or restitution programs give victims an opportunity to claim all relevant losses, but it's usually limited to economic losses. In the United States, we handle victim compensation in one of four ways. So it's either a component of the Victim Witness Program, which we'll talk about victim witness programs, or it's through kind of mediation. And we'll talk about mediation when we talk about restorative justice, but mediation is essentially victim offender reconciliation. Or it's ordered by the court. The two additional avenues are court ordered. So it's ordered in conjunction with probation or parole supervision, or it's through a court-based employment program. So essentially, those are the four ways that we have chosen as the United States to handle victim compensation. With those four ways in mind, let's turn our attention to the actual Crime Victims Fund. In case you didn't know, the United States does have a pot of money dedicated to victims, and it's called the Crime Victim Fund. And the Crime Victim Fund was established by VOCA. Remember when we talked about the Victims of Crime Act? That act, in essence, essentially set up funding opportunities. Well, it did that specifically for crime victims through the creation of the Crime Victim Fund. This fund, there's a lot of myths around this fund, and I want to bust the biggest myth right now. The funds that are in the Victim Fund comes entirely from the offender. It is not a taxpayer-funded fund. In fact, all of the monies that go into the Crime Victims Fund come from like fines, forfeitures, and penalties of the offender. So the offenders are the ones that are paying the monies into the Crime Victim Fund. And victims can petition to be reimbursed through the Crime Victims Fund. And it essentially awards money to crime victims. Now, how do they go about doing that? Well, The amount of compensation is based on the victim category. So go back to the beginning of this lecture when we talked about primary and secondary and tertiary victimization. The Crime Victim Fund categorized the level of victim, and only certain levels are able to tap into the Crime Victim Fund. And it's mostly primary victims. So there is a maximum cutoff for this fund, and the maximum compensation is between $10,000 and $25,000 based off of the category. But the victim has to take steps in a certain time frame in order to get funds from the Crime Victims Fund. So the victim has to notify within 3 days of the offense, and then they have to file a claim within 2 years of the offense. So the victims have to notify VOCA that they were a victim of a crime within 3 days of the offense. After that, they then have to file a claim with the Crime Victims Fund within 2 years of the offense. If they wait and go 3 years after the offense occurred, they're not going to be eligible for reimbursement. And a lot of the Crime Victim Fund is reimbursable funds. So victims may have to pay out, but then they're reimbursed for their expenditures. So let's look at some of the statistics between 2019 and 2022, just so you can see how often VOCA has been used in the Crime Victims Fund. So there's been a total of 28 million crime victims identified by victimization type from VOCA-funded assistance programs. Victims of domestic violence accounted for 26% of the victims who received assistance, and more than 3.7 million victims of child physical or sexual abuse received assistance. The most common type of assistance to victims was criminal civil justice systems assistance. That would be kind of like reimbursement for medical expenses and things like that. Here's a chart. It's not great. You'll be able to see it on the PowerPoint, but it kind of breaks down the type of crimes associated with the victim, as well as the number of claims that it paid and what it paid for. So this chart is really cool, and I got it off of the VOCA website because it tells you exactly what the fund is paying for, whether it be crime scene cleanup. Things that we don't realize is like if somebody is murdered in a house, it's up to the family to clean up that scene. Like crime scene investigators don't magically clean up the scene and all the blood and all of that. There are special agencies and specialized people who you can hire to do that, but it is ultimately up to the victim or the victim's family to have that cleaned. And so we see crime scene cleanup as a common reimbursable expense that the Crime Victim Fund or VOCA can help with. You see that there's dependent cares, medical, funerals, burials, things like that. So look over that. You can kind of see where is the money going. And I always like to highlight that because I always like to see where the money is actually being spent. And here you can kind of see where the money is being spent. And it's even cooler because you can see where the money is being spent in terms of what type of crime is occurring. Here's another. This is your victimizations based off of crime types. Here's that chart just put in a different way. This one only covers 2019 to 2020. You can kind of see how paid for different expenses. So now let's turn our attention to victim services. And we've talked kind of about the history of the victims' rights movement, how we got to where we are today, some of the major federal funding, and the purpose of that federal funding, VOCA. Please don't forget VOCA, and please don't forget the Crime Victims Fund. So now we're going to look at the services themselves that victims get. You will notice as part of the Crime Victims Bill of Rights that it's stated expressly that the victim of crime has a right to be heard and a right to attend trials. So how do they do that? Well, there's something known as victim impact statements. And these statements are, you will see, have been highly controversial, but we use them today and still utilize them to this day. But in essence, victim impact statements are generally prepared statements detailing physical, psychological, financial, and social harms to the victim that the victim suffered as a result of crime. So in essence, these reports can either be verbal or written, and they are either provided to the judge to read at sentencing, or the crime victim themselves gets up and reads it at sentencing. Victim impact statements are done after adjudication has been completed. And so after the guilty verdict is in and waiting for the sentencing portion, that's when the victim impact statements come into play. Victim impact statements were first introduced in the 1970s, which is pretty common knowledge and tracks with our history that we just went over. So remember, the 1970s was really the crime victim rights movement, and so you saw these victim impact statements being incorporated because the whole purpose of that movement was to bring a spotlight back onto the victims. However, victim impact statements were not always admissible in court. There wasn't really a law governing victim impact statements until the 1990s. And then in the 1990s, we started seeing victim impact statements, or VIS, becoming admissible into courts during the sentencing phase of the court. There's been a lot of studies around victim impact statements and the purposes of victim impact statements, and there's really mixed results on the effectiveness on sentencing decisions. However, there are, like, length of sentencing decisions, but there are some research findings that suggest that victim impact statements have an effect on the types of sentences given. One of the biggest court cases involving victim impact statements was R versus Jacobs. And essentially, this case involved a home invasion in the middle of the night where the victim's hands, feet, and face were bound. Her hair was cut using a knife, and multiple physical and sexual attacks were perpetrated on her. We go through the trial, and the offender was found guilty. The victim was able to give a victim impact statement around kind of detailing the impact on her longitudinally. And the perpetrator appealed that sentence, saying that the victim impact statement unjustly influenced him to have a longer, more severe sentence. Well, the judge in this case emphasized the importance and laid out 4 ways that victim impact statements contribute to the victim feeling heard. Now, it is very important that you listen to what I am about to say. In no way, shape, or form does victim impact statements bring relief to the victim. In no way, shape, or form does being heard bring justice to the victim. but it does let them feel like they have a part in the process and that they are heard. So Judge Stuart Berry emphasized the four major contributions that these type of statements have. So while it may not make the victim feel like justice has been fully served, it does foster an experience of justice in that the victims are able to participate in decision-making processes of sentencing through giving a statement. It also makes the offender aware of the damage that they have caused the victims. Offenders are rarely exposed to the harm that they do, and they may not care. And in a lot of times, they don't care. However, they need to be made aware that their actions have immeasurable consequences on individuals that they may have randomly chosen. Victim impact statements also allow us to measure the severity of crime. The victim telling the court what they have went through, it makes the court acutely aware of the impact of crime on the victim and the community itself. And then finally, it raises community awareness. We know that most superior court, entry-level district courts are public access. The public can go in and listen to trials. You can stream them online. You can go in person. They're open to the public. So by the victim being able to tell their story and how the victimization impacted them, they are then aware. They are then bringing awareness to the community itself of the impacts of crime. So by bringing this community awareness, they're able to hear from the victim kind of what needs to be done to mitigate at the community level potential crimes, whether street lights need to be put up or um, or police patrol, things like that. There are policy implications that can come from increased community awareness. So Judge Stuart Berry laid out these four um, contributions that victim impact statements have. And when we talk about victims in the justice system, we're going to talk about a Supreme Court case that upheld the constitutionality of victim impact statements. Victim impact statements are widely utilized now. They have been constitutionally protected, which you will learn about in Chapter 5. And they are one of the major services that victims can get, is just writing their experience and being heard. So with the continued effort and the rise in recognition of victimization in the 70s, the federal government was really kind of trying to figure out how to focus our attention. And so the National Office of Victim Advocacy, NOVA, was founded and established in 1975. And essentially, NOVA is the national umbrella organization dedicated to victim services, new program development, and supporting the passage of victim rights legislation. So NOVA is an umbrella organization that oversees victim services throughout our nation. We had VOCA, which is the Victims of Crime Act, that specifically passed and was landmark legislation to address the victim themselves. NOVA is a broader organization that's focused on growing, maintaining, and developing services for victims. So NOVA's been around since 1975. In 1988, the legislature established a specific office for victims of crime. And this OVC is what we call it, Office of Victims of Crime, provides substantial funding to state victim assistance and compensation programs, supports training needs for advocates, and offers tools and resources for service providers. So the Office of Victims of Crime is the official governmental agency that focuses on crime victims now. So NOVA was our agency up until 1988 when the Office of Crime Victims was established. But NOVA is your basic umbrella agency that does a lot. It gives technical support. The Office of Victims of Crime also kind of oversees the governmental side of things. But there was this rise locally of what is known as victim witness programs. We called them VWAP for short. VWAP programs really started in the 70s during that crime victim rights movement, but expanded exponentially in the 90s. And essentially, these programs are typically housed within the local prosecutor's office, and they are specialized personnel that just deal with victims and witnesses. They are victim advocates there. They help organize witnesses and kind of help walk witnesses through, but a majority of their work is dealt with victims. They help victims tap into the Crime Victim Fund, the state crime victim funds, all of that. These programs were designed to encourage witness cooperation in filing criminal charges as well as testifying in court. So you may have a victim who is a victim of a crime, but they then turn into the witness, because we know that still a crime committed is really a crime against who? The community. And so prosecutors are viewing the community as a victim still, and the actual personal victim themselves is a witness of that crime to the state. And so victim witness in this sense is really the same person. They have different roles, just based off of the way our system is set up. But the victim witness programs make sure that the victim is notified of those hearings and is prepared to testify. They work with them to tap into funding resources. I actually interned with the local victim witness program when I was an undergrad, and I was able to kind of talk with victims of crime, sit with them in court, be their support person. I was able to kind of help explain the processes and what the different court hearings were meant to do so that they had an understanding, made sure that they were able to access the online Crime Victims Fund, help them fill out paperwork. All of that type of administrative stuff was really kind of meant to be done with these VWAP programs, because it takes specially trained people to know what is out there. VWAP programs do not offer clinical services themselves. However, they do help victims navigate what resources are out there. So that is a very important distinction to make sure that you are aware of. We have evaluated victim assistance programs. In fact, the major evaluation was known as Vision 21, Transforming Victim Services. It was the first major evaluation in 15 years. Essentially, the goal of this study was to transform the treatment of crime victims in the United States. We wanted to make sure that we were supporting them the way that they needed to be supported. And in essence, the findings of that Vision 21 study showed us some things. It showed us that we really needed to be cognizant to integrate research into victim services. We needed to expand accessibility and availability of legal assistance. We needed to bring our technology up to date. We also needed to have strong infrastructure. So, like I said, with VWAP programs, hopefully every prosecutor's office has a VWAP program, but when you get into like rural Georgia, you have one prosecutor office who covers multiple counties. And so that VWAP program covers multiple geographic locations. And so are you really getting the best service and advocacy if you have multiple locations that you're having to cover? And so Vision 21 really kind of helped us lean into building adequate infrastructure in our victim services arena. All right, so as we kind of wrap up this week, we're going to talk a little bit about trauma and PTSD and the impact of crime on victims. Your book goes into great detail about the medical aspect of impacts on the victim. I'm going to do a high-level overview because it is important that we talk about this. So we know that crime impacts the victim in several ways. We've established that in week 2. However, the strongest impact a criminal act has on a victim is psychological. You have health impacts and financial impacts, but being a victim of a crime stays with you psychologically longer than any other scars. And it's important for professionals working with victims to understand some of the psychological impacts. The major psychological impacts that crime has on a victim is post-traumatic stress disorder. Now, you have in your book the complete criteria for diagnosis of post-traumatic stress disorder. I will not be requiring you, in any sense of the word, to diagnose anyone with PTSD. However, I think that it is important that you realize what it takes to truly diagnose someone with post-traumatic stress disorder. What are the professionals looking at? DSM, which is the Diagnostic and Statistical Manual that clinicians use, is very clear as far as what it takes to diagnose. And the concept of post-traumatic stress disorder really kind of came to fruition with soldiers returning from the Vietnam War and the whole emergence of the rape trauma syndrome with the rape movement. So we started seeing that there was some significant mental health issues going on with these victims. And so it is important that you understand that the diagnostic criteria for PTSD in the 5th edition of the DSM, which is the Diagnostic and Statistical Manual, includes a history of exposure to a traumatic event and symptoms from one of 4 symptom clusters. So you have to have a major traumatic event that happened, and then you have to have some symptoms from the 4 clusters. And I have these clusters on the slides. You don't have to memorize this. This is for your information only so that you can kind of understand what you're working with. So stressors, intrusion symptoms, avoidance, things like that are all present. Your book gives you explicit detail on what to look for. So like your stressors would be like direct exposure, witnessing. Your intrusion symptoms would be like nightmares, dissociative reactions. Avoidance would be trauma-related thoughts or feelings, things like that. Then you get into the mood alterations. And here you're really talking about emotional regularity. So, have there been negative alterations that began or worsened after the traumatic event? Or has there been an increased arousal or reactivity that began? Are you hyper focused now where you hadn't been? Are you always looking over your shoulder? Does every little make you jump? Things like that. They also look at the duration and some of the functional significance that you don't really need to know. But just take a look at that. I'm not going to be too expressly hard on testing on that. I just really want you to know there's a lot that goes into a PTSD diagnosis, and a lot of our victims have PTSD. So this whole entire population that we're working with, we have to be cognizant that the trauma that is inflicted because of the crime has lasting psychological effects. You will want to read a little bit about the limbic system, and how trauma affects the limbic system. We see a lot of flashbacks because of the way trauma interacts with the limbic system and the different hormones that kind of are released during that. So finally, let's talk about the major treatment modalities. So we have victims that we know have PTSD. How do we get them help? Well, we are not counselors. Most criminal justice professionals are not clinicians. There are clinicians within the criminal justice profession, but we are service links, bridges. I like that word. We're service bridges. And so we need to be aware of the services that are out there and kind of what helps our clients. Again, remember VWAP programs, victim witness assistance programs, they don't provide the services themselves like clinical services, but they do link the victims there. And so much research has been put into cognitive-based therapy. And there's even a new form of cognitive-based therapy that's specific to trauma. So it's trauma-focused CBT. But cognitive-based therapy essentially is the method utilized, realizes that behavior is learned rather than an innate process. So it typically will be utilized to undo that learned behavior. So it's highly effective in reducing the severity of PTSD. Several studies have shown that cognitive-based therapy is probably the best modality in terms of PTSD, specifically trauma-focused. A lot of child abuse victims that I worked with had TFCBD, CBT, and it helped them tremendously. However, cognitive-based therapy is a long process and can be a long process based on the victim's willingness to open. There's a lot of trust that has to be built and things like that. So finally, your book, your reading will go into some additional therapeutic modalities. Again, I'm not going to be too focused on therapy. Just know CBT, cognitive-based therapy, CBT, and psychotherapy are typically the best avenues to treat PTSD. All right, like I said, this was an extremely long lecture. There was a lot of material this week, kind of going over victims' rights and victim services. Feel free to go back and rewatch what you need. I hope you all have a great week, and as always, I'm here if you need anything. Feel free to reach out.